Thank you, Your Honor. Ladies and gentlemen, first of all, on behalf of the state of Tennessee and the people of Nashville, I'd also like to thank you for your service. I know you've left your homes and your families, and you've been here with us for a long week now. And this has been a very difficult case for you to listen to. And we really do appreciate you. Without your service, our system of justice cannot work. I usually stand here and talk about what the issues are and have to respond to several things. I've been doing this 39 years, and I've never seen a case where we had videos, we had photographs of the actual crimes being committed, and you've seen them. It's important you remember what the judge will tell you, that you decide this case based on what the witness testified from the witness stand. And they can throw around other statements they made. Those aren't substantive evidence. It's what they said from that witness stand. And I know all of you took a lot of notes, and you can go back and look at things. And Mr. Perez is right. We disagree on a lot of the facts in this particular case, is how it was said or what was said. He first of all talks about count 5. So evidently, he feels the state has proven beyond a reasonable doubt all the other offenses occurred, but he talks about the penetration vaginally in count 5. So what evidence did you hear? Well, you saw the video of Mr. Batey. And the law does not require an erection. It doesn't require much penetration. It says, however slight. And you saw him mounting the victim. And you heard the testimony of Mr. McKenzie that after he put his penis in her mouth, which he saw, that he went back and did it again. And you heard Mr. McKenzie tell you that he told him that he penetrated her. And then ask yourself, why would this defendant, Mr. Vandenburg, flush the condoms if he didn't think there was evidence on them, if there hadn't been a penetration? Why would Mr. Vandenburg go over the next day after talking to his co-conspirators and have sex with her to cover the evidence if penetration didn't occur? Now, the state has proven, as Ms. Norman very ably showed you, every offense was committed in this case, Mr. Banks and Mr. Batey, except count 8, which Mr. Vandenberg's even acknowledged he committed. So, when you've got all this evidence on video and pictures and surveillance video, what do? You don't talk about the videos. You talk about the police or the victim. You attack whoever you can. First person gets attacked is Detective Gish. Talk about an iPhone, whether it was an iPhone 4S or an iPhone 4. Mr. Vandenburg destroyed it, so what does it matter? That's a real issue. And then he talked about, oh, you saw the search for a Samsung phone. Who owns a Samsung phone? Mr. Banks. Was that what the search said? What does the Google search say? Can police receive deleted pictures and messages? It just happened to show up on Samsung. He didn't search Samsung. Nobody searched Samsung. That's Mr. Vandenburg searching. And that's a small thing, but that's something you have to pay attention to. And then he talks about this preliminary report he did for General Norman, that the times are wrong. And he explained that to you. There's a bug in the software from Oxygen that caused the times to be off an hour. And it was fixed. He got new software from him. That was a preliminary report. And what does it show? It shows what you know from the evidence. From her receipt on her gold card, she got there right at midnight. You heard all the witnesses say she got there right at midnight. So what does that have to do with the case? Nothing. Another red herring to throw out there to attack the police. And he kept talking about, oh, the photos weren't date stamped. Well, you heard Detective Gish say, yes, I can show from the computer when this photograph taken from Detective Mayo was, and he did, because we heard so much from Mr. Perez about the computer being in the room when the police searched it. You saw photographs, and then you saw the photograph when it was recovered the next day. That was shown to you. So don't be misled. Another thing was a big photo sequence that we had to go through an hour on. One photograph was moved before it went to the server, and he showed you what the photograph was. It was a picture of the front of Gillette Hall, which they moved up to the front of the photographs. That's great police misconduct, wasn't it? Another total red herring to distract you from the evidence. So next, let's attack Captain Harville, a licensed attorney, who explained to use sensors. There wasn't anything spliced. Said they're action sensors. They all have different sensibilities and things like that. Anybody's had those security lights on your house or a game camera or anything else, you know it's all can be different. There wasn't anything about, you really think Captain Harville's going to go in and slice out video? No, the only video got destroyed was by Brandon Vandenburg. So then he talked about Mr. Vandenburg, you know, the security showed him coming up to the RA to get help. There wasn't any testimony about that. He may have gone up to look to see if the RA was in there before he brought unconscious Elizabeth Lackey in the dorm, not to get help, to make sure he could get by the RA. And said they went to the apartment, he tried to get in. Well, that's what he told the police. But you heard Lauren Miller, her roommate, say, I was there at 3 a.m. Nobody knocked on my door. Nobody called me. That's what he told the police he did. He simply got to that apartment, I submit, and saw her roommate was home and decided to go somewhere else to do what he wanted to do. And then let's attack the victim. Let's attack her. You know, she's gets up and does menial things like go to the restroom and get a drink. Doesn't commit crimes. Do a lot of things you might be able to do in a confused state, whatever was in her body at the time. She didn't commit a crime. And he talks about her smiling when she walked out at noon, by the way, several hours later, and she was looking at her phone. Just because she didn't feel good and she felt horrible doesn't mean you could see something on your phone that might be funny. And he talked about the blue, you heard whatever this was with this transcript today about Miss Martell trying to recall and said, oh, yeah, I said that, but then right after it I said, I'm not sure that's what was said. And when I questioned her, she said, yeah, she could have said that she bought me a drink. She could have said it was another drink. I don't know. I really don't know. Does that impeach Elizabeth Lackey? And did she say he was buying her drinks like they said? No, she said another woman was buying the drinks and Mr. Vandenburg was bringing them to her. She didn't say that. Yes, let's attack the victim. And then let's attack Detective Mayo. What did he not do? Although they want you to believe you know, all he had done when he talked to Vandenburg was look at a few still shots. So he listened to Mr. Vandenburg. He did what police do. Tried to befriend him, tried to get him to keep talking. He kept saying, well, he believed him. He believed him. Maybe he did at that time. He didn't know anything. He hadn't seen those videos. He hadn't even seen a surveillance video. He hadn't found out about the destruction of evidence. They didn't ask him on that witness stand, do you believe Mr. Vandenburg today? Did they? No. Another red herring. And talk about Detective Mayo, oh, he didn't process the rooms. They weren't crime scenes. By then, it was almost 5 days after crime occurred on the second floor. What was he going to process? He did go look, and he found a white watch, which he photographed because it was on surveillance video. Mr. Batey, which later would come in handy as evidence, he didn't really have probable cause to seize it at that time. So what was he supposed to do? Just nitpick the police. Don't worry about the evidence. Let's talk about the police. Said Mr. Vandenburg cooperated with the police. He lied to Vanderbilt. He lied to the police initially until he started sweating. And he said, I don't trust those other guys. They're liable to say something bad about me. And then he told the police part of the truth. Only part. He didn't tell them about his condoms. He didn't tell them about the porno. He didn't tell them about deleting everything. He didn't tell them about a lot of things. He gave him his phone. Yeah, that's true, after it was deleted totally. And even after talking to the police, that's when he went to California and destroyed the cell phone. Tried to destroy a hard drive. And then they showed you the picture of Mr. Vandenburg, how upset he was. Mr. Vanderwall with his hand on him. Was he upset about the victim? No, he was upset because he was stuck there and had no plan. He had to call his buddies. And Mr. Vanderwall was right here testifying. Did they ask him, was he upset? What did he say? Was he upset about this? What did he tell you? He said he never said anything indicating he had any concern whatsoever about the victim. Never said anything. No, he was only concerned about himself. Then we go back again about Detective Mayo and Mr. Prelude. Mr. Prelude, here he is, 18 years old, just got to campus a few weeks ago. He's rooming with this big junior college recruit coming in, who's friends with the big players, quarterbacks and wide receivers. And here he is, a little lowly walk-on kind of guy, laying up his bunk after trying 2 beers. And he gets woke up in the middle of the night by this. And I don't think he ever testified that Mr. Banks said everything. He said, I heard sexual statements being made. I heard the F word several times. And I heard Mr. Vandenburg say, I can't get an erection because I'm too high on cocaine. And he said, I heard porno coming from down by his bed. He never said he identified Mr. Banks' voice. He identified Mr. Vandenburg's voice. And they want to say the police didn't investigate his bedding. Well, they'd heard from Mr. Vandenburg. He didn't say he did anything. You heard from Mr. McKenzie. He said he didn't do anything. You heard from Mr. Prelude. He said he didn't do anything. And do you really think that they were going to come in and say, hey, let's throw this victim up in the top bunk. That'll be a good place. Let's all get up there on the top bunk. Does that make any sense? No, it's just another red herring thrown out there for you to consider. He said Mr. Banks talked to him a day or two later with Mr. Batey and Mr. McKenzie and told him they needed to help him out. That's the only thing I recall in the record he ever said that Mr. Banks said anything to him. But he could identify the voice of the person he'd been living with for 3 weeks, I think. And Mr. Quinzio, I'll get to him a little bit later, but Mr. Quinzio, he says that he sent back these videos because he couldn't remember sending them. Well, how did he know to request to get them? Oh, the only reason he sent to get them back I submit it's because he'd run around and deleted all of them, and the little guys had got together now, and they want to know what was on them exactly. In his cooperation with the police, he didn't turn those over, did he? No, I don't think so. And he kept harping on him about, you didn't say, you heard him say, squeeze it, squeeze it, squeeze it, and he didn't. He didn't hear that. He was asleep part of the time. There was a lot of noise going on. He didn't recall that. He said, I heard a lot of sexual stuff going on. I didn't say it. I don't know if they thought because he identified his voice that he was now saying he heard that. That's not what he said. He said, that's his voice. That's the person I've lived with for 3 weeks. He talks about Miss Lackey with her blackout. What did she really say? It's been a long time since I've been in college, but she said she went to sleep in a car after drinking, and she woke up immediately when somebody woke her up. And then she went into the dorm at the same time, and she didn't remember some of the stuff the next day. That's not really what you call a blackout, I don't think. She said, I've never felt like this. I've never had this experience. That's another, I submit, exaggeration of what's in this record. Let's talk about Mr. McKenzie. Here's Mr. McKenzie. Young man, 18 years old, been out drinking with his 2 buds, his roommate. Little buzz, comes back, gets in the middle of this. He doesn't deserve any medals, that's for sure. He's not going to get any. But what did he really do? We know he didn't touch her. At least there's no testimony, no video, no photographs of him touching her. We didn't hear his voice encouraging anybody or anything. And he admits he took pictures with Mr. Batey's phone, not his own phone. He didn't use his own phone to take pictures for his own gratification or whatever later. He took pictures from Mr. Batey. And he left the room a couple times to look at his phone, go to the bathroom. He was a lot less interested than the others, I submit. But what he did was not right. He was there laughing, he was there photographing, and he lied to cover it up. But you do have to give him some credit that he finally came forward to tell the truth. Yeah, he gave a first statement. He told you, I lied.
Did you check his vouching?
All right. He lied at Vanderbilt. He told a lie. Stuck with a game plan. Lied to the police. And then what did he tell you about his third statement where he met with the police and the representative district attorney's office? By that time, he talked to Chris Boyd, and they knew what was on the video that had been sitting back, I'm sure. They knew what was on the video. What did he tell you? He said, I was trying to tell the police what I knew they had and nothing else. And nothing else. And he said, I exaggerated intoxication. I exaggerated a lot of stuff trying to make it look less serious than it was. That was his testimony. And he said, no, I didn't say Cory Batey penetrated her with his penis vaginally or put it in her mouth, because he didn't think that was on the video. In that statement, he didn't say Mr. Vandenburg slapped her one time and said she's not going to wake up. And do you really think that after he gets charged and he comes in and gives a statement that they talked about in the DA's office, the only thing they brought up was he said something to his lawyers about a storyline to make sure he recalled everything like he discussed with them. Nothing else inconsistent. So you really think that he's going to come in and say, wow, I've got to make something up on Mr. Vandenburg. I got to make it up. Let's make it good. I'm going to say he slapped her one time. He's going to lie, don't you think he'd come up? He could have said anything. Could have said he had sex with her. Could have said he urinated on her. Could have said anything. But what did he say? He slapped her one time after Cory Batey slapped her several times. She's not going to wake up. You saw the visual evidence. And you didn't hear a single thing about that statement on the storyline or the 2 prior testimonies he's had in other hearings where he testified under oath. You didn't hear a single prior inconsistent statement brought up about that. Now, talked about him saying he was never involved, and he explained what I meant. He didn't sexually assault her because he couldn't get an erection. That's what I meant. And when that text they kept bringing up, he said, I was responding to the last part that says, you're not going to talk. He said, correct. He said, you're not going to cooperate, basically, or talk to the police. Correct. The other one was a question mark. You don't say correct to a question. You say correct to the statement that you're not going to cooperate with the police, but they try to say that. And you heard his testimony under oath. Now, he is an accomplice under the law. There's no question about that. Here's what the law is on an accomplice, as the judge will tell you. It's sufficient if corroborative evidence fairly legitimately tends to connect the defendant with a crime charged. In other words, under the law, you can't convict somebody strictly on an accomplice testimony. There's got to be other evidence tying that person to the crime. I mean, they could say anybody was there committing a crime with them. You have to have specific evidence. Of course, in this particular case, here's what corroborates Mr. McKenzie. The video obviously corroborates Mr. McKenzie. Photographs, as he described, corroborate what he says happened. The surveillance video corroborates what he says happened. Mac Prelude, he heard the same comment from Mr. Vandenburg about not being able to get an erection. He heard the pornography that he talked about. He heard sexual comments that were talked about. He saw them all in the room together. Dylan Vanderwall. This defendant told him a bottle was used. This defendant told him people had sex with her. This defendant told him he sent a video out. All those things corroborate. He also told him a lot of stories. And Mr. Vanderwall said, yeah, at first he said nothing happened. Then he said, I was passed out. Of course, neither one are true. And he gave him the details, the video, the bottle, the sex, him not being able to get an erection and a destruction of condoms. Text message is a cover-up. Mr. McKenzie talked about how they got together, even acknowledged by the defendant in his statement, the cover-up. Fingerprints on the condom box in Mr. Vandenberg's room, in his drawer, of Mr. McKenzie, Mr. Banks, placed back in there after the assault. Do you really think that they brought those down there and put them in his drawer? Computer search, we know. He talked about the pornography. We know that happened. And the urine, he testified to urination. Even Mr. Vandenberg confirms that. But it's also confirmed by the police identification section that came in and smells urine strongly. So Mr. McKenzie is clearly corroborating. So let's get to the elephant in the room, I guess. The only real issue in this case is they say Mr. Vandenburg was too intoxicated to be held responsible for all of his actions. That's what we talked about. Intoxication is not a defense to a criminal case normally. In other words, the law says if you go out and get drunk, it doesn't matter if that impairs your function. It doesn't matter if it makes you lack judgment that you might have had. It just doesn't matter. You're still guilty. If you drink, it makes you aggressive. If you drink, it makes you do things you might not do if you're sober. You're still guilty. It's not a defense. The only time it can be a defense is if you lack the capacity to form a knowing mental state. It's not is it impaired. It's not is it diminished. that you do not have the capacity to have a knowing mental state, which we've talked about. It's an awareness of the circumstances that surround you. That's a pretty low standard. An awareness of circumstances surrounding you. He wants to compare our victim, who was unconscious for a long period of time, to Mr. Vandenburg, who's running around doing all kinds of things. Well, I think you've seen the evidence, and you can tell the difference there. Let's see what shows Mr. Vandenburg acted knowingly. Now, this is testimony on intoxication. Here's Mr. Quisnio. That's their key witness, evidently, on intoxication. What did he talk to him for a minute, something on the phone? A minute? And what was happening during that minute, if you recall the timing, that's when the porno was playing. And Mr. Quisno said he was talking to another person as well as him. And he may have used the word gibberish, but he also said, he said he told him to call him back, so he obviously understood something. But look at all the circumstances, and that's 1 minute. He didn't see him, he didn't observe him, he didn't do anything. That's a 1 minute call. And then you look at everything else Mr. Quisno testified to. He was getting text messages and FaceTime messages from him. And you heard yourself, Mr. Vandenburg talking. It wasn't gibberish. And that's what they want to rely on as their key witness. A 1 minute conversation from somebody in California in the midst of all this, saying he couldn't understand it. His best friend at the time when he talked to the police, he sounded really drunk and out of it. Well, of course he'd make excuses for his friend. Warren McKenzie said, yes, he'd been drinking, but yes, he had no trouble communicating, no trouble walking. He was being bossy, ordering us around. He didn't testify that he could not form a knowing act, that he wasn't aware of his facts and circumstances surrounding him. Elizabeth Lackey, she said he was fine. She's the only witness you heard from that actually saw him drink alcohol. She said he had a Red Bull and vodka and 1 or 2 shots. She wasn't sure, but it could have been 2. A cinnamon whiskey. Juliana Martell, she saw him at both the Bristol and at the Tin Roof. She said he was fine. She didn't observe anything unusual about him. He sure knew where he was, obviously. Andrew E. said he had a brief conversation with him, and he knew him as a teammate. Didn't observe anything unusual, not slurring his words, not falling down. Dylan Vanderwall, one of his best friends, another tight end, a guy that he calls on to come help him, and he spends the night with him, goes to breakfast with him. He said, well, yeah, he was intoxicated, but not overly intoxicated. I'd seen him intoxicated like that before. Wasn't anything unusual for him appearance-wise. Yeah, I could tell he'd been drinking, but he communicated. He walked. Surveillance video, you saw all of it. Was that the action of a man that's so drunk he had no awareness of the circumstances surrounding him? I mean, all you had to do is what he was doing, driving a car, knew where he was going. I mean, the crime scene video, obviously he was describing what he was seeing. He knew exactly what was, he was aware of what was going on. He could even tell whether Mr. Batey's penis was hard. What did he do to promote or assist this crime? And the intoxication defense of knowing really makes sense if you look at criminal responsibility, because what does it say? That you have to have the intent to promote or assist another person in commission of a crime. So it makes sense that you'd have to have an awareness that a crime was going to be committed or is being committed before you can assist, solicit, direct, assist, or offer to assist. So that makes sense that you have to have an awareness. So let's see. He provided the victim unconscious, took her right up there, provided the room for the assault, made the statement according to Mr. McKenzie, what he was going to do to her, provided the condoms, took videos and pictures, sent them out, encouraged Batey and Banks both, played pornography for his benefit, and maybe them too. Covered the camera with a towel, destroyed condoms, deleted a video on Carter Samuel's phone, lied to the victim what happened, had sex with her to cover it up. Destroyed a cell phone in California, tried to erase a laptop in California. All those are acts. Knowing acts, intentional acts, that make him criminally responsible for this crime. Now, the court's going to tell you, I think, that mere encouragement of the principal offender is sufficient to be criminally responsible for the crime. That's all it requires, that you have an awareness that a crime is being committed and you encourage the commission of that crime. That's why this case is really, when you cut from all the talk, so simple. Squeeze that thing, squeeze it, squeeze that thing, squeeze it, squeeze that thing. Watching a bottle being placed. That's all the law requires, ladies and gentlemen, for criminal responsibility. Now, there's some inferences of guilt also. One is, as a juror, you can infer guilt from certain actions of a person. One of them is destruction of evidence, because the law says if normally people don't commit crimes, don't go around destroying evidence. So if you're destroying evidence, you may even infer guilt from that fact. There's another inference I think the judge will tell you about. Presence and companionship. It basically says if you're a person and you're with a person before they commit the crime, you're with the person after they commit the crime, and you're with them during the commission of the crime, that you as a jury may infer guilt, and the requisite criminal intent may even be inferred from that. Now, obviously, Mr. Vandenburg was with him before the crime, during the crime, and after. His own statement, Mr. McKenzie, they met on 2 different occasions. You saw how he and Mr. Batey attempted to call each other back and forth 19 times. He called Mr. Batey at 4 o'clock in the morning. You may infer guilt from that alone. Now, that's June 23rd, 2013. And that's her, after meeting this defendant, Mr. Vandenburg, a man she trusted, a few hours later, dumped out there like throwaway food, dumped out in a public hallway where anybody can walk up and see her, like a piece of trash. Experience she'll have to carry with her the rest of her life. Here's Mr. Vandenburg over East Hall at 4 o'clock in the morning watching. He's having a good time. He's laughing. Look at him. He's really concerned about her, isn't he? Laying over there unconscious. They're having a big time. That's the evidence in this case, ladies and gentlemen. This was Lackey had the courage to come in here and ask for justice for what was done to her that night. She had the courage to come in here and face Mr. Brandon Vandenburg, the person she trusted. I I'm just asking you to have the same courage to follow your oath and apply the law to the evidence, as Judge Watkins tells you. And if you do that, you follow your heart and your mind, you know what a just verdict is. If you do that, justice will be done.
All right, ladies and gentlemen, we're going to take our final recess. When we come